Thanks for joining this episode of the number 86 lecture series, in which Professor Richard Epstein discusses property rules in the Roman law. Episode 3 includes the rules of acquisition and development, whether or when occupation of property is necessary, what things can be considered property. This lecture is part of a series with Professor Epstein on how this ancient legal system can provide crucial insights about modern problems. Professor Epstein is one of the most prominent legal scholars of our day. He is the inaugural Laurence A. Tisch Professor of Law at NYU School of Law, a senior fellow at the Hoover Institution, and Professor of Law Emeritus and a senior lecturer at the University of Chicago. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Let's start with a basic question. How does the concept of private property arise in a society?
We said, first of all, you have rights in your labor by a kind of an implicit autonomy assumption. Then what happens is you have rights in the things that you acquire by first possession. And the rights of exclusion are torts. But the dominant relationship is relationships by way of contract. And these contracts can allow you to sell services. They can allow you to sell property. They can allow you to give licenses to people to enter into your property. They can allow you to divide property, to mortgage property, to lease property, and so forth. So the private law system creates this rich transactional network of immense subtlety. And so what the Romans did in their relentless fashion is they then decided to develop three kinds of rules. First of all, the rules that deal with the acquisition of various forms of private property, and then the rules that deal with their transfer, then the rules that deal with essentially their protection, and then related to the property rules, but often considered separately from it, there's this theory of restitution, which talks about the ways in which transfers of property can take place in legitimate fashions, even though there is not a voluntary transaction between the two parties. So now when we start to look at this, I've mentioned the fact that there are three bodies of law, and it's important to understand what they are and the relationships between them. The first thing is we've decided that property was a res nullius in the state of nature, which means that nobody could own it. Well, if it's always going to remain a res nullius, then farming will never start to take place. Nobody could build a house. And essentially what we would do would have what is known as a negative commons. Nobody could enter this particular thing to use it. Everybody is forced to keep off. And, that's not a particularly helpful situation. So you have to find a way in which to get this stuff out of collective solution and out of immobility into private hands. And the rules of acquisition, based upon the theory of occupation, which I'll talk about, are the one set of rules that are allowed to do this. And in fact, you only want a single set of rules to deal with occupation, because the moment you put in two alternative rules and they're inconsistent, then you have to decide a priority between them, so that the Romans had the right result, which says it's a uniform principle of occupation that governs this. And then quite sensibly, they realized that different kinds of resources would require different rules with respect to what counts as occupation, without having any problem of competition.
Can you elaborate on these rules that govern acquisition?
Well, to begin with this system, generally speaking, the first question you have to ask is how it is that somebody gets something which was in the commons, i.e. owned by nobody, and reduces it to private possession. Now, this is logically the point that you would start with, because unless you can acquire a possession and title of land in one way or another, it's pointless to figure out how you can get exclusive use of it, and it's pointless to figure out how you can transfer it in one form or another to anybody else. And so if you're going to start this as a logical matter, possession should come before transfer and protection. If you look at the Justinian Digest and Gaius's Institute, you'll see that they don't have the same order. Gaius does not begin with possession and acquisition. He begins with the rules of transfer, whereas Justinian inverts the situation and begins first with acquisition. Why is that? Because if you go back and you start looking at the hierarchy of laws, essentially the sort of natural law rules, which tell you how these things run in a state of nature, are thought to be inferior to some extent to those rules and formalities that are created by the dictate of the emperor. And so the transfer rules by way of mancipatio in particular, that is by formal transfers, are essentially created by the state. So you start talking about those first. Then what you do is you move on to talk about what happens when the formal rules of transfer aren't honored and you have illicit and incomplete transfers, and then you turn to possession. Whereas by the time you get to Justinian, all of the formalities are largely eliminated in this thing. And so he goes back and goes to the correct order first, starting with acquisition. That's exactly the same thing that, for example, John Locke does when he starts with his treaty of property in Book 5 of the Second Treatise of Government. Now, the first thing what you have to do is to understand what the Roman law was and why it's sufficient about that. The term that they used was occupatio, loosely translated as occupation. And what they meant by that is that the rules of possession require two things. One, that you actually occupied, that is, took over the particular property. And two, you gave notice to the rest of the world in one form or another so that they knew that you had made this particular claim. There was nothing in there which limited the amount of land that you can take as a matter of positive principle to only that amount of land which you could usefully cultivate and so forth. All there was you could take it so long as you could put it in. Clearly, if you start thinking about the way in which things work, there's a very difficult trade-off for people when they're starting to acquire, let's start with land, the most important asset. If you try to acquire too much land and you try to fence it in, you don't have enough material to fence it in, and what's going to happen is animals are going to not respect anything you're doing. They're going to wreck the property. Your neighbors will not be particularly interested if the whole thing's open, so they'll take it from you as well. So the way in which the original acquisition does, they're kind of natural principles that start to limit the amount of land that you're going to acquire, in part by the amount of land that you think you could protect against outsiders. Now, why is it that protection works within this system? Well, there's a fundamental relationship that everybody understands, which is that if you have a defensive position behind walls and somebody else tries to take it over, if in fact you are weaker than him, you still may be strong enough in a defensive position. And the rough estimates, depending on where you are, is that the attacking force has to be about 3 to 5 times as large as the defending force in order for it to overrun people. So now you can see how the kind of initial equilibrium works, not only with respect to clans, but also with respect to individuals. Let's assume that you're twice as strong as I am. Obviously, I'm not going to attack you, so you're safe. But on the other hand, your 2-to-1 advantage isn't big enough for you to attack me. And so long as the ratio between the two parties is relatively close, it turns out that you'll get a stable equilibrium. If one guy gets very, very much bigger than the other fellow, say 5 or 6 to 1, there may be a deal which will avert conquest and yield some surrender of rights, but conquest may well be in the position. So property is always fragile, and the more equality that you have between the groups, the more stable it's going to turn out to be. The fatal encounters will come where the attacker thinks that he's got a 4-to-1 advantage, when in fact he only has a 2-to-1 advantage. So given his mistake, he's going to start to attack, but given your resources, you'll be able to defend successfully, but both of you are going to be very badly bloodied in this situation. So to some extent, full information actually is a source of stability, and that can exist between private parties. So what happens is if you're reasonably modest in the way in which you claim territory, and the guy next to you does it, there'll be stable relationships. And then what will happen, if in fact you learn to develop some degree of trust, is you'll start to trade, and the trade will essentially improve the position of both of you with respect to everybody else. And if you go a little bit further, you may then agree on common boundaries, which means that the amount of perimeter protection that you need relative to the amount of space protection that's protected goes down, which works to the benefit of everybody. So it turns out, although there's a rivalrous element to the first possession rule, there is also a cooperative element.
How much can you develop your own property?
Now, once you have this particular resource, the first thing you can do is you can start to develop it. So you have to know exactly what it is that you have. And the basic instinct that one develops is as follows. Property has both a temporal and a spatial dimension. On the temporal dimension, if you acquire a piece of property, essentially you acquire this thing forever. So there's no artificial time barrier which tells you how long you can use this stuff. This is very different from the rules that govern the use of huts in times of storm. That's on public property. And the moment the peril passes, your ability to use the hut on the public property passes as well. All relationships created by necessity are necessarily of short temporal arrangements. They last only as long as the necessity goes. But when you're trying to figure out how you cultivate land or build a house, and you put any temporal limitation on this, you can only have it for X years. The closer you get to that barrier, the more awkward the transactions are going to be. So essentially, the dominant solution in virtually every case is if you acquire something by acquisition, you acquire it essentially in perpetuity. And you may be able to create by contract limited interest in that particular thing, but there is no government restriction saying for this far you may have it and no further. In addition to having the temporal arrangement, there are also spatial arrangements. And how far do you go? The Romans did not actually systematically answer this question, but it turns out the medievalists who followed on the Romans developed what was known as the ad coelum and the ad inferos rule. Ad coelum meant if you own the surface, you own clear the way up through the skies. So if you could imagine a cone going up from my land, not only would I be in the upper atmosphere, but I could be all the way out to Jupiter and Mars and so forth, and nobody would stop me. And then the ad inferos rule means that you take my land and then you put it down narrower until we get to the center of the earth. So I own all of that. Clearly, the further you get away from the surface of the earth, the less valuable the rights turn out to be. But there was no reason in Roman times to restrict them in an artificial fashion. So if you could only build for 100 feet, why do you want to have a 150-foot rule if somebody's going to put an antenna on the top of the thing and so forth? So it would go all the way up. Going down was extremely important because if you owned the underground stuff, it meant that you had exclusive rights to the minerals that turned out to be there. Interestingly enough, although this was not a Roman issue, if there was water or oil and gas under the land, stuff which was, to use the word, fugacious, which sort of moved around from place to place, the old system would not work particularly well. But those issues did not really come into play until the sort of late 19th century, when the more intensive use of water resources and the development of oil and gas rights essentially made you create important exceptions to the particular rule, which we can talk about very briefly here. So you're going all the way up and you're going all the way down and you're going all the way forward in time. And what you do now is you have something that is clearly worth acquiring. But as it was with the water rights, surely enough, whenever you go this far, sooner or later you're going to run into some technological development, to some reason, which is going to start to talk about why it is that some sensible limitations might be placed upon both the upward and the downward movement. But before you want to talk about the exceptions, you want to understand how the basic system started to work. So with these as the definition of the property rights, then the key questions you have to ask is, how are these things acquired? Well, the answer is you acquire occupation of the surface. You get by imputation, as they say, all the stuff going up and down, and you get it indefinitely. And then after the acquisition rules are done, you try to figure out the transfer rules. These are of two sorts. Some transfers are out and out, so you're gone and the new guy is in, and those are relatively easy to structure. But the really important and difficult cases are those of divided interest, where somebody else gets some portion of the total and you keep some residual portion of that. So now you've got two or more parts, and you have to make sure that there are no gaps between the two parts so that waste will take place, and there's no overlap between the two parts so that you don't get conflicts with respect to uses. And it's an amazing how much of the Roman law has to deal with that thing in connection with chiefly the law of usufructs, which I mentioned in connection with water law, which actually comes back to play an extremely important part in the general Roman law dealing with property after it turns out to be acquired.
What happens after property is acquired? Does it have to be occupied? And what does that mean?
So now that you take these things, what is it that you have to do in order to get it? And the rule of occupation was a very slim rule. What you said is as little as possible is what is needed to make sure that you have differentiated yourself from somebody else. So you have to be able to mark the boundaries and give some indication that you're actually there, using and cultivating the land, which could be very, very minimal. Now, why do we want this rule? The basic logic of the rule is if, in fact, you required more in order to acquire possession, you would dissipate the value of the property by expending enough labor to do it. So in the limit, if you said, here's a piece of land which is worth $100, and you have to invest $100 in this land in order to perfect title, what's going to happen is nobody will bother to acquire land, because if you spend 100 to gain 100, why bother to do anything at all? So the first possession rule says if you can get away with spending 2 instead of 10, that's $8 more of surplus. So we minimize the amount of stuff that you acquire. When you start looking at the theoretical developments of this, in the common law, there's no deviation whatsoever from this particular kind of rule. Everybody kind of understands the logic of the implicit surplus that takes place by minimizing the formalities that are needed to demarcate land. Then comes along John Locke, and he completely messes this up because he announces that there's a labor theory of value of enormous influence, which says that the way in which you acquire ownership of property is to mix your labor with the thing. At no point does he ever mention the word occupatio in his thing. Everything is how much you put into it. Well, under this theory, you can start to say, oh my God, if you only put in 2 units, you're only entitled to 2 units, and so the other 98 units will be regarded as quote unquote an unearned increment, and that ought to be socialized in one form or another. So the labor theory of value, if you do it that way, says that you only acquire value to the extent that you put value in, which means that you never do it. So this theory is a colossal blunder to the extent that you're trying to explain how property rights ought to be acquired against neighbors. And it essentially is almost indistinguishable from the Marxist theory of the labor theory of value, in which you say that the value you add to property is the only thing that you're justified in keeping, and this so-called unearned increment, that is the excess value over your contribution, belongs to the society at large. So you have to get rid of the mistake, and then you ask yourself, well, when, if at all, do you really care about how much you put in? And there's a very different situation to which this model applies. Let's suppose I own something, and now we're getting to the law of restitution, and I own a plane or a boat. And it turns out that you're a subcontractor, and what you do is you give me a value of improvement to the boat of $100 on a $1,000 boat. And it also turns out that the general contractor doesn't bother to pay you. And you have not given a lien waiver. So now the question is, you've given $100 of value to somebody else who's improved his boat. Are you supposed to go with nothing? And the general answer has always been, no. This is a case of unjust enrichment, as I mentioned earlier. You're now entitled to a lien on the boat, which is for $100. If he doesn't pay you off, you can then literally force the boat to be sold, get you $100 and give him the residue. But since he knows that, he'll pay off the $100 and get it back. Now, that's a classic case in which you want to give the guy $100 because the property rights have been well established, and you don't want somebody to get something for nothing as a private benefit. But that situation is completely different from the situation in which you're taking something out of a state of nature and reducing it to private property. Or to put it another way, if you had actually done the contract correctly, the guy would have been paid his $100. And now what you're doing is you're giving him a remedy which gives him the same $100, but doesn't allow him to touch the greater value of the ship by claiming it his own because there's a difference. So the rule with respect to these liens is that you only get the amount that you've put in, and the labor theory of value makes perfectly sense there, even though it makes no sense in the stranger cases. But if you start looking at the standard philosophical treatments on that, most of the people who write about the labor theory of value do not understand or work well within the Roman tradition, so they don't see the enormous difference that it creates. The labor theory of value means that the unearned increment goes to everybody else, and the occupation theory means that the original owner keeps it. This is exactly essential in every form of property. So if you're dealing with something like patents, for example, you want to create a rule in which minimal amount of labor will tell you what's covered by your invention. You can't do it by putting stakes in the ground or building a fence, so you have to file papers. But essentially, minimum proof is what is necessary because you want to make sure that the surplus is not dissipated by the principles of title perfection. And so the Romans got this thing exactly right. So that's the first question about why it is that we use the world of occupation.
You mentioned types of property besides land, such as an invention. Many types of things can qualify as property. Are the rules the same for the usage and ownership of all types of resources?
So the question that we then have to face in all of these contexts is how does this particular rule play out with respect to different sorts of resources? And they do present very serious problems of one form or another. And first of all, with respect to land, generally speaking, you can't just look at land and say, I hereby possess this. What you have to do is to take some affirmative steps that give permanent notice to the rest of the world that you have treated this thing as your own. What that typically means in an ancient society is you have to mark the corners of the land. You have to put boards up in one form or another. You have to start cultivating the land so that anybody who looks at it would realize you don't see these nice rows of flowers and beans and trees in there. As a matter of nature, only a man can create it, so you know somebody else has done it. So now you're under a duty to keep off because it's been claimed. And so the notice provisions, you'd like them to be as cheap as possible. But remember, they're going to be very different in very different areas. If you're claiming small parts of agricultural land, generally speaking, you've got to give pretty clear demarcation. But if you're talking about scrub land where the useful amount of land to occupy has to be very much larger because the per acre value is much lesser, then maybe just putting up a bunch of posts around the land or a barbed wire fence would be sufficient to tell everybody else that they have to keep off that particular property. And sure enough, in some cases, there may be that a stream on one side will mark the natural boundary on a land, and in other areas, there won't be any streams at all. So basically, the amount of demarcation you have to do is going to be a function of the kind of terrain you have. There's early texts, mainly from an author known as Paul, who said, do you have to occupy the full amount of the territory within the boundary? And if you start thinking about it, the typical person standing up occupies maybe 1 square foot of land, lying down maybe 6 square feet. You want to claim, lots of land. You can't put it all in your hand. You can't lie down on it. So the basic rule is if the boundary is clear and you make some small use of any fraction of it, everybody else has to understand that you've protected the whole. And so the Roman rules of possession with respect to land under this form are exactly the same rules of possession that we have today, because the fundamental problem is the same today as it was in any other time. So if you're dealing with an upward acquisition of property, the first possession rule starts to tell you what it is that you have to do for possession. You want to make it onerous enough so that you differentiate yourself from the rest of the world, but you don't want to make it so onerous that you actually dissipate the value of the resource that you're kind of protecting. And the occupatio rules that the Romans developed with respect to land really meet that kind of a question on the basic place. Now, when you start moving to other kinds of resources, it's going to be a little bit different. So suppose you're now talking about animals, and how do you create this thing? And the answer is, well, these things could run, so you have to capture them in some way, shape, or form. Well, what's the rule going to be? Everybody agrees with the famous rule that if you actually lasso the animal, capture it, and keep it in your possession, then in effect you have prima facie ownership of the thing. But the ambiguities then come in 2 additional kinds of cases that are worth mentioning because they appear again in exactly the same form in the great case of Pearson and Post, decided in New York around 1805. And the first thing is, suppose it turns out that you're chasing an animal and you wound the animal, which continues to lumber along, and before you can actually bring it down, some saucy intruder, as we like to say, comes along and first captures it. Can that guy claim the property against you on the ground that he's the first possessor, the first occupier of the thing? And every legal system says no to that. And why is it? Because now you are thinking a little bit about the labor theory of value. The one guy does all the work in order to get the thing down, and the other guy comes in and does virtually no work at all. If, in fact, the rule were that the saucy intruder can prevail, then you treat it as though it's a theft of labor. So the general rule under these circumstances is that the outsider has to stand aside and give the guy who essentially engaged in the hunt the opportunity to finish this thing up and to capture the animal in question in order to make it its own. And it's a perfectly sensible rule, and it starts to show you that, like everything else, the occupatio rule has to have fine gradations as you start moving to different kinds of resources. So then the second question that you have with the simple animal runs as follows. Suppose that you're engaged in hot pursuit of the animal, but you've yet to hit it, but you've worn the whole thing out. Our saucy intruder comes along now, and what he does is he managed to capture the stag, which is exhausted after you've worn the thing out, and says, it's all mine, it's not yours. If you look at the Roman law text, for the most part, what they say is either it's wounding or nothing. And yet the same problem about the labor value essentially starts to take place. And so what you do is you get a battle of the two views on this question in Pearson and Post, which is really quite remarkable. On the one side, what happens is somebody says, this is a matter of jurisprudence. We start looking at jurisprudence. If you haven't taken occupation, it's not yours. And the other guy said, what are you talking about, jurisprudence? They're a bunch of hunters. They're in a community. They're in constant repeat interaction with one another. These are high-frequency, low-value interactions, only the value of this animal. You do it 1,000 times. And if the custom of the trade is that everybody has a chance when they're in hot pursuit to finish it up, first of all, you ask why it is they have the custom. And secondly, why it is that you would want to deviate from it. Well, it turns out there are two reasons why you want this particular rule in most cases, one of which is the same labor theory of value. You expend the labor. Somebody else can snatch it away from you at the last moment. It's a theft of labor. And so what you're going to do is really reduce the willingness to hunt or get people starting to become very hostile and start to shoot at guys when they want to steal their particular things. The second thing is that if you're doing the capture, it turns out you're trying to converge on a moving target. And if I'm going after this thing at full tilt and you come along and you're going after this thing at full tilt, then tumults and confusions are likely to emerge. And what the customary rule does is it avoids those kinds of things. So essentially what happens is if you understand why the custom is created, you're not going to rely on an abstract principle of positive law. If you have specific rules applying to a specific kind of animal in a specific location. Essentially, what custom says we have high amount of information about a particular setting, we ought to do it. So now suppose you start to change the setting. How is that going to influence things? Now, the Romans never talked about the way in which you acquired acquisition over whales, but the same rules really start to apply. And whales are pretty big. And it turns out that in many cases, what typically happens is that one guy cannot bring a whale down with a single harpoon. It turns out you need to have an entire boatload of people in order to get that harpoon in it. So sure enough, you need to have essentially a contract between the captain and the crew to allocate the amount that each person will get when it turns out that this particular whale or their fraction of it is done there. And this is done by contract. But with many kinds of whales, what happens is you put the harpoon in it, you can't capture it, and so it's going to be either beached or captured by somebody else. And now the question is, do you want to apply the first possession rule, which says that the guy who actually captures it is the fellow who's going to be able to keep the whole thing when the other guy has done essentially all the labor? So there's a famous situation where somebody comes across the beached whale, says, this whale is unowned. And so what's going to happen is I'm just going to claim it. And then the guys who shot it down says, no, the custom of the county has always been, if I basically deal with the whale and kill it and you find it on the beach, you will get compensation for giving me notice that my particular whale has come up there. So you're incentivized to give me notice, but you can't expropriate the whole thing. And so therefore, if you have sold the whale or the sperm oil from the whale, I'm entitled to get all of those proceeds, less the commission that you would otherwise earn. And so what they're trying to do by the modification of the first possession rule is to make sure that everybody who has an input gets a return from that greater than the input that they put in there. And you cannot do that if you give a wildly disproportionate rate of return to the fellow who happens upon the whale on the beach relative to the fellow who actually shot the thing down. And this is perfectly consistent with Roman principles, but what you're doing is you're creating a quasi-partnership between strangers, and the basic rule of a partnership is each member to the firm has to be able to get a return larger than his input, and then you divide the surplus. And if they're wildly asymmetrical inputs, what you ideally want to do is not to divide the total gain 50-50. What you want to do is to give each person the same rate of return on his investment that the other guy gets. So if I put in 98% of the work to kill the whale and you put in 2% of the work to give it to me, you get 2% of the gain, I get 98% of the gain, because that's the maximally stable arrangement. And custom will basically get you to that particular equilibrium, which is why it's accepted. Well, then there's a third situation. Suppose it turns out that what you do is you manage to deal with a whale and wound it, but it flies away, sails away, or swims away, and it turns out that somebody else captures it down the road. And that's a much bigger job than the one that you had. And so the whaling custom was no longer does the second guy get a trivial return. What you did is one guy got the sperm oil and the other guy got the carcass or something like that, so that there was a rough division between the two of them, again, proportion to the amount of labor that's put in. And so this first possession rule, which starts out very naively in connection with a single fox and so forth, changes as you start to have different animals and different customs. Now, Gaius doesn't spend so much time talking about this, but when you get to Justinian, he says, now what are we going to do with other kinds of things like birds and bees and so forth? And you just take the one case of the bee. It's a hive. Do you have to capture each and every bee in order to be able to claim the hive? Or do you have to show that you've managed to contain control of the tree in which the hive turns out to be located? And almost invariably, what they do with resources like this is they follow the same basic notion. As little as possible is needed to differentiate this thing. We don't want people to dissipate wealth in order to secure title when notice has already been given by less expensive and less intrusive means. And so they're all the way with that. So that's the first part of animals. But what about the second part of animals? Nobody has ever seen a piece of land run away after it's been acquired. Nobody's ever seen a chattel run away after this thing has been acquired. And with a chattel, of course, you could pick it up in your hands or put it in your barn, so the question of boundaries never arise. But with wild animals, this does take place. And so you have to have a rule. What if this animal starts to leave? And the obvious situation is that oftentimes when you have animals at night, you keep them in a barn for safety. And in the daytime, what you do is you let them wander around the hills in order to graze, and then they come back safely at night. And if you had a rule which said, the animal is now out of your possession under these circumstances, and so therefore somebody else is entitled to take it, that's going to essentially make it impossible to run animals. So the rule is that you retain possession of this particular animal until it has lost the capacity to return. How do you know this? Well, you don't do a mental study of the way in which the animal is, but if essentially it's out in the field and all the previous days it's come back, you're going to assume it's going to come back. But if somebody sees this animal in a rather shabby state 35 miles away, kind of lost and deranged, you could assume that it escaped and now it's back to the state of nature and somebody else can acquire the possession of it. It's an extremely astute rule with respect to this.
Can you talk a bit more about possession and how it works?
So this problem then also comes up with respect to land. And this is essentially a point on which both Blackstone and Bentham, for all their differences, agree. And what they do is they agree with the Roman rule. The Roman rule on possession was as follows. Once you have acquired possession of a particular thing, you retain possession of that thing, maybe only in thought, right, or by intention, until the thing either escapes the animal, right, or you abandon the thing, or you voluntarily transfer it to somebody else. Now, most people thinking about transfer would say, this sounds like a pretty technical rule. Why am I worried about this particular rule? Well, essentially, it's the rule on which all civilization necessarily stands. Because what both Bentham and Blackstone do is they assume the counterfactual to the Roman rule, which both of them have endorsed. And now it turns out what you do is you go into your house, you build it, and you're sitting in there, nobody could come in, and then you decide to leave it in order to go into town. It is now empty, and somebody else comes in and says, you left your particular property, so therefore I'm not allowed to take it. And if it turned out that every time you departed from the premises, it became a res nullius again, it means that nobody would ever be able to build anything or to keep it. So the rule has been exactly what I said it was. You're going into town. Nobody thinks when you're buying provisions that you're saying about this house of enormous positive value or that you've abandoned it, right? Nobody thinks that you've sold it. So essentially, you remain in possession of this thing even when it's no longer within your hands or your stuff. So the term possession starts out by thinking of a person putting their hands around something and holding it, and after a while, What you have to do is to extend the conception a little bit further, or it turns out that the whole system of property rights collapses. And one of the ways to say this is if the natural meaning of the word possession is you have something in your hand, if you then extend the right, what you're doing is you're creating a Pareto improvement over the previous state of the world. By giving a more extensive definition of possession, it means that the value of the property increases markedly. It's true for every particular owner on the face of the globe. And so therefore, what we do is we adopt this new definition of possession rather than the old one. And the Romans got this thing dead on right. They didn't give the full explanation of it, but they understood that this obviously accorded with natural reason. What they meant by that is the assets would become worthless unless you could protect protection, even though you were no longer in physical possession of the situation. So you add the word physical, then you put the word legal in there. It becomes a bit of a terminological jungle, but the developments are perfectly sensible under these circumstances about the permanence of these kinds of relationships. You then have to develop rules of abandonment, and there's a simple rule of thumb in this particular area. If something has positive value and is sitting there on the street, you do not assume that this thing was abandoned, because why would somebody abandon something of value? You assume that it was lost, and then you may be able to get a reward if you return it, but you just can't take it on your own. If it also turns out that you put something on the curb and say to everybody in the world, here are a bunch of books I'm no longer reading, pick them up, at that particular point, you treat these things as though it's abandoned. And the interim case, which turns out to be a big Fourth Amendment issue, is I put something on the curb and it's understood that I want it to go into the waste paper bin. Can another individual come in and look through my papers, either a private person or the government, on the ground that they've been abandoned? I think the correct answer to that question is everybody from the social context knows that this is out here in order to be picked up, not to be read. But if you look at the United States Supreme Court, they have given the opposite rule on this situation, which now means that if you want to protect your stuff, you really have to chop it up before you put it on the street corner, because the federal agents or the state agents could come in and look at it. So this possession question about how long you keep it and how you abandon it or have you abandoned it turns out the Roman terms to absolutely carry over to the modern situation. And interestingly enough, you'll do much better on the search and seizure rules if you understand the Roman rules of possession, why they were developed, how they got carried over into Anglo-American law, and why it is that the basic Roman connection on this particular issue was completely correct.
Thank you for listening to this episode of the Number 86 Lecture Series. The spirit of debate of our Founding Fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 Lecture Series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number 86 for lectures and videos on federalism, separation of powers, the judiciary, and more. That's fedsoc.org/NO86. Thanks for listening. See you in class.